Good morning, folks. My name is Greg McLawsen. I am the Affidavit of Support lawyer. I help green card holders enforce rights under the USCIS Form I-864 in federal court. And I wanted to talk today about a case involving a kind of unusual issue, which is an eviction lawsuit. This is the Belaya v. Belia matter coming from the District of New Jersey. And this is an interesting case to me in kind of a roundabout way. So let me describe why this is important to me as somebody who represents people who are enforcing the affidavit of support. I want to start with a basic concept, which is the idea of subject matter jurisdiction in federal court. And I know that sounds like a wonky lawyer term, but let me explain why it's important. Jurisdiction in this case refers to a court's ability to hear a legal dispute. In the United States, we have courts of limited jurisdiction and courts that have general jurisdiction. A federal court has limited jurisdiction. In basic terms, federal courts in the United States can hear disputes that involve either federal court matters, federal law matters, or disputes between parties living in different states. But the basic idea is that federal courts deal with federal law issues. The affidavit of support was created by federal law, and most federal courts have had no trouble deciding that they have the ability to hear disputes under the affidavit of support. What federal courts do not have authority to deal with, however, is general state law disputes. So if somebody walks up to me on the street and punches me in the nose, that's called a tort. Tort deals with things like negligence in car crashes and things like that. If somebody punches me in the nose, I have a claim against them. But I can't bring that claim in federal court because it doesn't have any relation to federal law. That is really important in the context of affidavit of support cases, because here's what happens. When a sponsored immigrant with claims under the affidavit of support files a lawsuit in federal court, the defendants have an incentive to make that lawsuit as difficult as possible for the person bringing the claim. So what happens often is that the defendants will try to pile on all sorts of claims that don't have anything to do with the affidavit of support, but they want to make it as hard as possible for my client to move forward with their case. Something that I have to deal with very often in federal court is going to the judge and saying, Your Honor, the defendant in this lawsuit has brought various counterclaims against my client, the green card holder. But those claims don't have anything to do with the affidavit of support, and the federal court lacks authority to hear those claims, and they have to be dismissed at an initial stage in the proceeding. That's a very, very common initial strategic move that we have to make in these cases. Okay, so why is the Belaya case important? Here's what happened there. In this case, we had a couple of parents from Russia who immigrated to the United States. They were sponsored by their US citizen children. We don't know all of the circumstances from the federal court rulings in this case, but it looks like the parents were not working and they started living with their children. At some point, things apparently weren't working out, and the parents tried to evict the children, the US citizens, tried to evict the parents. Now, I don't want to get too into the weeds of eviction law. It actually wasn't technically an eviction action. It's called an ejectment action. That is the sort of civil proceeding you bring when there's no formal landlord-tenant relationship. In this case, since the parents were living there without any sort of lease agreement, the petitioners, the affidavit sponsors, had to bring an ejectment action to try to kick the parents out of the house. So that's working its way through the state court system in New Jersey. And the parents, who were the green card holders, sponsored by the people who own the house, said, wait a minute, we are unemployed. You're kicking us out of the house, but you guys signed an affidavit of support promising to provide financial support to us if we need it. And we certainly need it because you're kicking us out and you're about to make us homeless. So what happened was this went to arbitration in New Jersey, and the petitions, the green card holders, the folks who were the beneficiary of the affidavit of support, tried to take advantage of a procedure called removal. Removal is a matter in a state court and you're dealing with a federal law issue. You can take it out of state court and remove it to federal court. It looks like what the green card holders were trying to do, and it makes a certain type of sense, was to argue in the federal court, look, we are getting kicked out. These guys are making us homeless, but they signed an affidavit of support for us. These guys have a binding financial obligation that is enforceable in federal court to provide a basic safety net for us. That's an intuitive argument. And what makes that argument especially appealing to me is here's what would happen if these guys, the green card holders, if they had brought a federal lawsuit in New Jersey to enforce the affidavit of support while all of this is going on, I 100% guarantee you that the argument that the defendants would make, the people who signed the affidavit of support, 100% for sure, they would say, hey, we don't have any obligation to provide money to these sponsored immigrants because we're giving them a place to stay. So the defendants would want to use that same set of facts, the fact that the green card holders were living with them. They'd want to say, look, that shows that we are providing support for them and we don't have any extra liability. So this is a very, very closely related claim in the sense that from the sponsor's perspective, giving the green card holders a place to live is probably a way of fulfilling the support obligation. At least that's going to be their argument. So in the universe of potential claims and how closely they are related to the affidavit of support, this is a really, really close call, in my opinion, because, again, giving the green card holders a place to stay, at least according to the sponsors that I talk to, is a way of fulfilling obligations under the affidavit of support. So it makes a real sort of practical sense for the green card holders to argue that these are really, really closely related claims. And the sponsors are kicking them out on the street and making them homeless when they have an obligation to provide financial support to them. So in my mind, this is like as closely related as two claims could possibly be in relation to the affidavit of support. But here's what the federal court in New Jersey did. It said, look, federal courts don't have any jurisdiction over ejectment actions. That's kind of the fancy term for the type of eviction case that this was. And that's absolutely true. Eviction cases, ejectment cases, those arise under state law. And as a general matter, federal courts don't have any business getting into those. And the court said in a pretty short discussion, look, the sponsored immigrants might have a claim under the affidavit of support. The court did not really question that, but the court said that counterclaim, the claim that the defendant green card holders could make, that cannot by itself create jurisdiction in the federal court. So the court sent the claim back to the New Jersey courts to deal with. Here's why I think that is, even though in this particular case, the green card holders did not get their day in federal court, here's why I think this is an important case for the green card holders that I represent in lawsuits to enforce the affidavit of support. Remember what I started with, which is that it's a really, really common strategy for sponsored defendants to try to throw as many counterclaims as possible against the sponsored immigrants. So I've seen things like elder abuse, totally crazy things like mandamus, which is this obscure writ under federal law. But basically, any idea that the defendant can possibly come up with about a legal theory they might have against the green card holder, they're going to throw that in there because every single additional claim throws a roadblock in front of me and my clients before we can vindicate the sponsored immigrants' rights under the affidavit of support. So what, again, I have to argue constantly is, Your Honor, federal court lacks jurisdiction over these pile-on claims under federal law. And this case, the Belaya case, is kind of, in one sense, it's my new favorite example of why federal courts have limited jurisdiction in these cases. Because in this Belaya litigation, again, this is like as closely related as you could possibly get. The affidavit of support is all about providing basic subsistence financial support to green card holders. And so in that sense, giving the green card holder a place to live, these are facts that are as closely related to what's called the operative nucleus, the core factual basis of a claim under the affidavit. It's as close as you could possibly get. And even in that circumstance, the federal court said, no, we are not going to use this federal tribunal as a place to deal with your ejectment case. So if that's true, if federal courts won't get involved when a sponsored immigrant is getting kicked out on the street and made homeless by the very same people who signed a binding financial agreement providing basic subsistence to those sponsored immigrants, if federal courts don't have jurisdiction over that situation, well, then for sure, they ought not to have jurisdiction over general counterclaims brought by sponsors, because those aren't going to be any more closely related. I'm dealing with a situation right now where a sponsor argues that the green card holder stole some important family heirlooms from them. Well, if we say that kicking a green card holder out on the street and making them homeless, if that doesn't bear a close factual relationship to the affidavit of support, well, then certainly something as unrelated as allegedly stealing a family heirloom from the house, that can't possibly be related either. So that claim can't be heard in federal court either. So it's kind of an ironic case to find helpful as somebody who represents sponsored immigrants. But I think, again, the Belaya case is a very helpful example to people enforcing the affidavit of support to say that federal court jurisdiction is super limited and you cannot have pile-on claims. Hope that's helpful. If you have questions about obscure issues of federal court jurisdiction and actions to enforce the affidavit of support, jump into the comments. I'm happy to answer them. If you would like an individualized case assessment, I meet with folks via Zoom, and you are welcome to contact me at soundimmigration.com. I do not charge for initial case assessments under the affidavit of support, and I'm happy to help you figure out if you have a potential claim. Again, my name is Greg McLawsen. I'm the affidavit of support lawyer. You can find me at soundimmigration.com. Hope that's helpful, and take care, everyone.